I'm a partner in the law firm of Seyfarth Shaw in Washington, D.C., and I'm head of the ADA Title III team. So basically, all we do is handle lawsuits and other matters that arise under this law, ADA Title III.
People might think there's just a ton of attorneys filing these, but then it comes down to there's a couple of attorneys that are filing the most. You call them serial filers?
Well, there are serial plaintiffs, and then there are who are the people who are actually filing the lawsuits, and then there are their lawyers. But we see the same ones over and over again. So, in Florida, Mark Cohen is a regular lawyer who files a lot of these lawsuits. And in terms of plaintiffs, I guess in 2015 we looked at who the top filers were, and we had Howard Cohan was a big filer. I think he filed over 350 lawsuits in 2015. We had Patricia Kennedy, who filed over 170 last year, and Tal Hilson, who filed over 130. So those folks really skew the numbers, obviously, because they file so many.
Why?
Well, I can't read their minds, but I mean, I think those folks are self-proclaimed testers. So a tester is a person who says, I'm going to go out there and test businesses to see if they're compliant with the law. And so they claim to visit a lot of places.
Right. What is the concern about so many of these lawsuits being filed?
Well, I think when you're looking at from the business's perspective, I think the businesses are frustrated because they don't think that people with disabilities are really having any trouble using their facilities at all. And so, why is it that these folks are suing them left and right? And a lot of the times the suits are based on very, technical issues, like is the toilet paper roll 7 to 9 inches in front of the toilet? So maybe it's 12 inches, right? Does it really affect accessibility? We don't really, probably not. But, those are violations, and these are the kinds of things that are being brought up in these lawsuits. It's not to say that there isn't a legitimate lawsuit. Sometimes there's no ramp and you can't get into the business, or the ramp is too steep and it's dangerous. But there are also just a lot of minutia items too.
And the business owners, at least we spoke to, in one case, the person who did the interview, the manager for the business, he's actually handicapped himself. They didn't have a handicapped parking space. They now do. He actually is handicapped himself and says, I like the fact, I guess, that we have a handicap, but they kind of thought to themselves that Tal Hilson was so concerned that he could have just gone in and spoken to them. Like, they kind of felt like they should have gotten a warning before they just found themselves in federal court.
There's a lot of frustration with that, and I think over the years there have been efforts to amend the ADA to require notification ahead of time. I think Mark Foley tried to get that passed, but it didn't work out. I think that the reason why there's so much difficulty is because I think from the disabled community's perspective, we've had this law for over 20 years, right? So perhaps people should know what to do. On the other hand, like I said, the law has a lot of details in it, and it's hard, particularly for small business owners, to know what they're supposed to be doing.
Particularly for small business owners in older buildings, though, as well, correct?
Absolutely, and the law does require that to the extent it's readily achievable. So unlike the building code that says, the next time you do an alteration, you have to do it according to code, what the ADA does is it isn't going to wait for that to happen. So starting from when the law was passed, businesses immediately had an obligation to start removing barriers to the extent it was readily achievable. Now, what's readily achievable for a small business, for mom and pop, is very different from a major hotel. Obviously, it takes into account difficulty and expense. But it's also a very hard thing to know, like what's readily achievable for your business, right? So that's the challenge. There are going to be issues at every place, simply because it's very hard for businesses to get everything right. Are the issues really impacting people's ability to use the facilities? Maybe not. So on the other hand, the statute does contemplate a private enforcement mechanism because the Department of Justice can't be everywhere. They're the ones who are supposed to be doing the enforcement. but they have limited resources. And so the expectation is that the people out there in the world can bring lawsuits in order to make these businesses more accessible. Under the ADA, you only get, if you're a plaintiff, you only get attorney's fees and costs. You don't actually get damages. Now, there is a component of the cost that would go to an expert who has to be hired to supposedly look at the facility and see if there is really a violation. You know, who knows what happens with that expert fee. The tester is going to be the plaintiff. It's the person with the disability who claims to have been harmed, right? The lawyer hires the expert, who is not necessarily someone with a disability. It's just somebody who is supposed to have expertise with respect to what the accessibility standards are. So that person would measure how high the counter is, or whether the slope of the ramp is okay. That's what the expert does. The people who are interested in suing just as a tester or just to make money, whatever the motivation is, they're always going to find something wrong with your property. Okay, it's really hard to be perfect. But the good news is that the vast majority of people with disabilities genuinely just want to be able to get into your business and you know, enjoy the same goods and services that everybody else enjoys. So there are going to be a few of these situations where businesses are going to feel like they're under attack, but they shouldn't, I guess, feel that way about everybody who's got a disability. Because I think, again, truly, most people just want to get in and be able to use the business.
Giving money to settle that suit without making the fixes doesn't really save you, because you're still not in compliance, and therefore somebody else could just file suit, right?
That's correct.
So once you get hit with one of these lawsuits, whether you like it or not, whether you feel like you're under attack or not, what is the best course of action?
It's good to fix the issues. It's good to fix the issues. I mean, at the end of the day, anybody walking into your business with a legitimate motive or not a legitimate motive can bring a lawsuit against you if there are these violations present. And so it's best to spend the money on fixing rather than fighting, in my view.